Okay, so Article 3, Section 16 now states that all persons shall have the right to a speedy disposition of their cases before a judicial, quasi-judicial, and administrative bodies. So in court, which refers to judicial, every person has the right to a speedy disposition of cases. What does that mean? There are requirements, okay, for a judge or even quasi-judicial body or administrative body, which are not actually judges, or some of them are not even lawyers. Okay, but in a judicial body, there are requirements in which the judge are allowed only to submit or decide the case. Now, in courts, there are actually a number of months that they're going to decide. Otherwise, there will be a penalty for a judge if he cannot decide within that period. Okay, so below you can see the number of months. For 24 months if submitted to the Supreme Court, and 12 months, or sometimes reduce it, okay, 12 months for all collegiate courts and 3 months for all lower courts. Lower courts refers to regional and municipal trial court. Okay, lower collegiate courts, okay, including Court of Appeals, it may be up to 12 months or 1 year. Now, what do you mean by 3 months? Okay, although in reality this may not be followed, but actually supposedly there are penalties imposed to a judge who cannot decide within this period. Okay, but because of court cases load in court, sometimes this is not followed. Sometimes it would even reach 10 years or even more, depending on the evidence presented. Okay, because that would also based on the evidence. Although it can be decided within this period, but if the evidence are not yet, or the trial is not yet concluded, then this may not be applicable. This only applies if both lawyers, prosecutors, and the defendant or defense counsel already submitted the evidence. Okay, for a while there's a call. Hello, sir. Yeah. Oo. Oo. Mm. Mm. Okay. Section 17. No person shall be compelled to be a witness against himself. What does that mean? Okay. It is called the self-incrimination, when you are required to produce evidence in your behalf, meaning the evidence that you produce will be against you. But take note, explanation, you have to listen carefully. This only applies to a testimonial evidence. This does not include physical evidences. For example, a pregnant woman, okay, and you are in doubt whether the child in the womb is belongs to the husband or the wife, the DNA test or producing an evidence to prove the guilt is self-incriminating. No, it's not self-incriminating. Why? Because it is physical evidence. The self-incrimination here refers only to testimonial evidence or testimonial compulsion, okay, and production of documents, okay, excluding in here many times the physical evidences. A handwriting, okay, in a case of forgery and you are compelled to write to prove that it is your handwriting, that is still, it falls under testimonial compulsion. Why? Because the handwriting, although it may be physical, but it can be dictated in your mind. So that would still fall under testimonial compulsion. Now, other than that, like production of evidence of a pregnant woman to show that he committed a crime, since it is physical evidence, that does not fall under self-incrimination. The meaning of self-incrimination simply means that you produce a testimony to prove your guilt. Now, sometimes this will be used by lawyers to so that you will be caught off guarded, and they sometimes ask you questions in several questions in a form of lump into one question. Okay, for example, you will be asked, are you the student of this school who steal the document? Well, the question is actually, if you answer that, that will be self-incrimination. Why? Because you are now, the answering it would mean the guilt. That is called self-incrimination. The answer of that question would mean an admission of a guilt or denial. Okay? So, why is it self-incrimination? Because the answer to the question asked would be used against the accused. Now, a lawyer, the defense counsel would say an objection. Okay, an objection, Your Honor. The question is self-incrimination. Okay, and of course, you've seen that in several instances in court or Congress hearings where the person invited will not ask, and they would say it's will not answer, and they would say it's self-incriminating. Okay, so anything that would an answer would lead to a conviction of the accused is called self-incriminating. Now, in the case I have mentioned, how are you going to answer the question? Okay, the objection would say that the question is self-incriminating. Then the judge would say paraphrase or rephrase the question because it's self-incriminating. Then it will be divided into two question. One question is that are you a student of that school? Okay, answer it whether yes or no. But as to the question whether he steals that document or not, then do not answer it because it's self-incriminating. Now we go to, I'm sure I'm clear on that. Section 18, no person shall be detained solely by reason of his political belief or aspirations. So what do you mean by political belief? If you believe in a certain belief of a political group, okay, you may not be convicted based on that belief or aspirations. Now, how about this? there are, I don't know if your connection is also interrupted. Mine is interrupted because, today most of the students are now using the um, internet. Okay, now I'll continue, but then there are actually videos I posted. Make sure you can watch it and make comment, because some of you were not able to view it. Please view and make comments, so that that's the basis of my perhaps grade as a participation. Okay, so there are actually posts which that's why if you notice, when I discussed it today, I jump, right? Because in my other class, I actually continue. So I posted it in our Google Classroom for you to view it, so that I will not keep on repeating. Okay, now going back to section 8, no person shall be detained solely by reason of his political belief. How about this new people's army? Okay, they believe in communism. Will they be imprisoned? No. In fact, the crime that they will commit is um, rebellion. Okay, and they may be given perhaps an amnesty, which is for political offenses. Okay, and that can be given at any time, at any stage of the proceedings. Whereas in um, pardon, it can only be given to other offenses aside from political offense, and it can only be given after the judgment. Now, so you will not be imprisoned, but if you violate certain rules, you will be imprisoned in the exercise of that political belief. Okay, so as a belief in itself, no one will be imprisoned, but in the exercise of that belief, you committed other crime, then you will be punished for the other crime, not on political belief. Now we go to section 20, paragraph 2 of section 18. No involuntary servitude for all from shall exist except punishment of a crime whereof a party shall have been duly convicted. What do you mean by involuntary servitude? How about compelling you to do a thing as a let's say in a contract, you were able to breach the contract. Let's say you are a housemaid and you are compelled to do a thing. Okay, would that be an involuntary servitude? Now, okay, the meaning of involuntary servitude is that when you are compelled to do a thing, okay, and you are not obliged to do it, okay, that is involuntary servitude. But the exemption is that if you are the child and your parents compel you to do something, then it is not an involuntary servitude. Or if you are a seaman, you are in the vessel and your contract ends in the middle of the sea, okay, and you are compelled to do something, okay, you can still be, it's not a violation, because it's of course for practical reason you cannot go home and the company will fetch you in the middle of the ocean. Or a military service, you're compelled to do something, it's not an involuntary servitude. Okay, what do you mean by punishment of a crime where the party shall be have been duly convicted? So you can be compelled if you are convicted. So involuntary servitude is a condition where one compelled by force, coercion, or imprisonment against his will to labor another, whether it's paid or not. So there are exemptions here. Just read this one. We go to section 19. Excessive fine shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty shall be imposed unless for compelling reason involving heinous crimes. Now, we go to this one. Excessive fine shall not be imposed. What does that mean? Okay, it simply means that the fine imposed should be commensurate. So it should not be, depending on the crime committed, it should not be. How about a person who committed a robbery, for example, or theft, and his name is, he roam around with a placard that I am a thief. Is that a violation? Yes, it is a violation. Okay, because that is cruel and degrading. Okay, it is inhuman if he steal and then you put a placard that he is a theft and he roam around. That is inhuman punishment. Now, the employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by law. Okay, so it's not allowed if the facility, even if you are a prisoner, you still have those rights to have a standard or adequate facility. Now, Section 20, no person shall be imprisoned for debt or non-payment of poll tax. What does that mean? Will you be imprisoned if you cannot pay your debt? Well, no. You will not be imprisoned if you cannot pay your debt. But as soon as you sign an agreement that we're going to pay on this particular day, you made a promissory note that you're going to pay on this particular day, and you are not, and you did not pay on that when the due date comes, then that will fall under deceit. Okay, will you be imprisoned yet? That is now estafa. What is estafa? Well, there's a deceit. You made a promise that you're going to pay, but you did not. So, what's the reason why no one will be imprisoned for non-payment of debt? Because the more you cannot pay the debt if you are inside the prison. So, you will not be in prison if you cannot pay the debt. So nothing to worry about if you have debt. Okay, make sure you do not promise to pay on that particular day. Okay, but of course they can compel you to set the date. When are you going to pay? Okay, so make sure that when you set the date when you're going to pay, you should really pay. Otherwise, that will fall under estafa. What is poll tax? Okay, or non-payment of poll tax refers to a community tax. Okay, a tax that you are residing in this particular place. Will you be in prison? No, it's just an obligation to the state. But you may not be in prison for non-payment of tax. It's just a small amount of money. Now we go to section 21. No person shall be put twice in jeopardy by punishment of the same offense. If an act is punished by law or an ordinance, one conviction or acquittal of either shall constitute bar to another prosecution of the same act. Meaning, if you committed an offense and the information is validly filed in court, then you cannot be charged anymore for same crime or related to it. Okay, what does that mean? Let us say rape, and then you are acquitted. I may only have 1 minute, but I'm sure I can finish this one. If this would end, perhaps you can just watch the videos I posted. Now, if you are convicted of the first offense, another another case filed against in relation to it, that is already double jeopardy. Okay, so what do you mean by double jeopardy? There are several cases or information filed against a person. That is double jeopardy. The acquittal of the other bars the prosecution of another offense related to it. So what are the requisites? There are 4. 1, valid complaint filed before the competent court to which the defendant already plead. He already plead guilty or not guilty. By that, then there's no more case to be filed against or even related to it. The acquittal of the accused would mean a bar of filing another case similar to it. Okay, the defendant previously acquitted or convicted. If he's acquitted, meaning no, he's not guilty, or convicted because he's guilty, he's in prison, you cannot file another case in relation to it. Now, in a case of rape, there are other cases that may be filed. Like, for example, when a woman is raped, touching of private parts is necessary. If the person is acquitted because of on the crime of rape, you cannot file any more